Welcome once again to the PodCase Podcast, where we answer your questions about personal injury cases. I am your host, Rusty Messer with Big River Trial Attorneys here in Baton Rouge, Louisiana. We are joined by our co-host, Maria, our client support specialist here at Big River. Maria, what question are we answering today?
How do you settle a personal injury case without going to trial?
Very common question. I think that question is not so common as the question we often get is, will my case go to trial? And I understand because going to trial can be stressful. It can take a long time to get there, and it can also be an expensive process. Uh, the good news is most personal injury cases are resolved long before anybody starts picking a jury or anybody starts getting on the witness stand. So there are really three different ways that personal injury cases get settled without going to trial. Probably the first and most common are just informal settlement negotiations. So this is where the attorney contacts the adjuster, says, "Hey, I represent Mr. Smith, or I represent Miss Thomas, whatever." And you exchange information with the adjuster. You're given the medical records, the crash reports, other data that proves the loss. Hey, I've got this witness. Hey, my client also had these expenses, uh, and just talking with the adjuster to try to work out a resolution to the case. It can be difficult to do if you're not finished your medical treatment because it's hard to settle a case until you really know how bad you're hurt. Like if you're going to need long-term care because of what happened to you, and there's a big insurance policy on the other side that may have enough to cover that care, you're really going to have to know how much your future medical is going to cost. But there's lots of cases where maybe, say, it's minor injuries, maybe a few months of treatment, stuff like that, where it can be done quite easily. So, what's involved? So, like I said earlier, your lawyer's going to gather the evidence, like the medical records, witness statements, stuff like that. So, once your attorney has in your medical records, has put together all of this, he or she is going to draft a demand letter. So, this is a letter that you send to the insurance company outlining, hey, my client was involved in this accident. This is why your insured is at fault. These were my client's injuries. These are my client's medical bills, my client's out of pocket expenses, and make a demand. And usually it's for the policy limits. Uh, at this point, the insurance company will usually take a couple of weeks to think about it. Then they're going to reply back with an offer. It's going to be probably much lower than what the demand was, but this starts the informal settlement negotiation going back and forth. The good side about informal settlement negotiations is it's usually faster and less expensive than any other form of resolution we're going to talk about. You also maintain control over whether or not you accept or reject an offer, as opposed to if you take your case to trial, what you are going to get is whatever the judge or jury says you're going to get. So informal settlement negotiations will start happening pretty early after the crash has happened. Uh, Probably the actual talking about settlement is going to take a little bit of time. Like I said, you have to get your treatment done, you have to collect in this evidence, get the crash report, things like that. But that process starts right after that when your attorney reaches out to the adjuster and says, "Look, I represent this person. Just letting you know, we're going to be presenting a claim, and I'm going to get you a demand package as soon as I'm ready." That is by far the most common informal settlement negotiations. A close runner up to that is what is called mediation. And now a mediation is a structured voluntary process where both of the parties, or all of the parties, if there's more than one defendant or more than one plaintiff, they meet. Usually it happens at a place with lots of different rooms. So you've got the plaintiffs are over here in this room. Maybe this defendant is in this room. This defendant is in this room. And there is a third party neutral person called the mediator. And he or she starts off by trying to see, what does everybody really already agree on. A lot of times in a case, we're closer on the issues than we think because there's some issues that nobody's really fighting about. Maybe liability is not really an issue and everybody sees that. So we don't need to start off the mediation arguing who's at fault. Maybe they're not that far apart on the numbers. The mediator might go to the plaintiffs and say, "Look, I know this is your demand, but what range would you be really willing to take? And goes to the defense and said, look, we know this is your offer, but what amount would you really be willing to pay? And the mediator keeps all that confidential, but the mediator then understands, like, hey, even though the demand is here and the offer is here, the parties are really here. So there's a lot of room to maybe where they might can come together. Uh, so what's involved in a mediation? You get each side presents its case to the mediator in a confidential setting. The mediator does not decide who's right or wrong, who gets what. The mediator just listens to the parties and finds out what issues do they already agree on and what issues can they get to agreement on. If an agreement is reached at mediation, it is put in writing and it becomes legally binding. They're enforceable. And if no agreement is reached, or even if there is an agreement reached, everything that happens at the mediation is completely confidential. So if the case doesn't settle at mediation, nobody can go to trial 6 months later and say, well, at mediation, you said this, because everything that happened in the mediation is off the table once that process ends. So the pros of mediation, uh, it's quicker than a trial. Uh, it cuts down some of the arguments when you find out what people are really fighting about, and it offers other creative solutions. It has lower legal expenses a lot of times. You're not deposing experts and things like that. And it avoids the adversarial nature of a trial where somebody has to get on the stand and testify. Usually, mediation occurs after a lawsuit is filed, but somewhere before trial. And in lots of places, the courts can even order mediation as part of the pretrial procedures.
How do you know who the mediator will be?
So usually the parties will propose mediators. They'll say, well, look, we like this person, and this person. And the other side might say, okay, well, I'm okay with this person, but not these other two. Or how about this person? So both sides have a say on who the mediator is going to be, so you avoid it being the defense attorney's cousin or something like that. Great question. So the third way that cases get settled outside of going have a trial is what's called arbitration. It is much more formal and it is much less common. So in arbitration, both parties present their case to a person called an arbitrator, or maybe one or more, which is called a panel, if there's more than one. Then this person hears the case and issues an opinion. And that opinion can be binding or non binding depending on what the parties agreed to going into the arbitration. So it's different than mediation, where the mediator is not deciding your case. An arbitrator is deciding your case. It's very similar to trial in that you do present testimony, you do present evidence, but it's much less formal and it's a quicker process. Uh, you can put witnesses on the stand. The arbitrator's decision is final if that's what the parties have agreed to. And a lot of times that happens in writing early on, even before the case comes up. When you go somewhere and you sign this waiver, you're going to, some sort of recreational place and you sign their waiver. You're admitting your loved one into a nursing home. You sign the waiver. That waiver might include an arbitration provision that, hey, if you're going to sue us, we're going to take this to arbitration. Uh, so some of the pros of it, it's much more private than a trial. It's a lot like mediation where everything that happens stays there. It's also less expensive and much faster than a drawn out litigation. It takes an incredibly long time to get a court to give you a date to have a 5-day jury trial because they have lots of people wanting those dates and not that many dates to give out. The cons of arbitration is that it can be binding if that's what you've agreed to. And if that is binding, you cannot appeal that decision. Uh, you are stuck with that decision, whether you like it or not. And there's also a lot less transparency than in a court, in a trial before in a courtroom. And the trial in court is open. Everybody can see what's going on. It's open to the public. What happens in arbitration is very sealed. So there might be things that happen in there that really the public should know about that they don't get to know about. Arbitration usually comes up when there is a clause in a contract, like I talked about earlier. The parties can also voluntarily agree to arbitrate a dispute, but it's much less common. There are some states, Louisiana, we do not have mandatory arbitration. There are some states, from what I've heard, uh, that there is actually some required arbitration of certain types of injury claims.
Is there a certain time in the case when settlement has to occur?
So settlement can occur before a lawsuit is filed, after a lawsuit is filed. I have settled cases in the middle of trial before. Maybe the defense sees it's not going as well as they had hoped. Maybe it's not going as well as we had hoped for our side, and all of a sudden the parties are just more agreeable. So typically, I think a lot of people are of the misunderstanding that, look, I was in a sitting at a red light, I was rear-ended, my case is cut and dry. My injuries aren't that bad. I've treated for a month. How come my case isn't settled yet? It's probably not going to settle that quickly. There's still a process, but it can happen from any time to a couple of months after the crash until in the middle of the trial. And there are even times when cases settle after the trial and somebody has appealed and they're going to go fight for another year and a half or 2 years on appeal, and the parties reach a settlement there. Any of those types of settlements usually happen through the informal process. Mediation usually happens, mediation or arbitration usually happens somewhere not too long after the suit is filed, but before the trial happens.
What are some of the reasons people choose to settle without going to trial?
One of the big reasons is a lot of people really don't want to get on the stand to testify. A lot of people are afraid. I have been on the stand to testify before for various reasons, and it's unsettling. Even for me as an attorney who has been on the other side hundreds of times questioning people. Also, people want the speed of a settlement. So let's say you get into a relatively minor accident, and so now we have a 2 year statute of limitations in Louisiana. But let's say after about 6 months into your case, we figure out, all right, it's really not going to settle. We're wasting our time trying to negotiate this case. So then we file a lawsuit. Now we file the lawsuit. There's time for the defense to answer. There's a discovery process, and you start taking depositions. Then, once that's done, you ask the court to give you a trial date, and they may set that trial date for a year away. So, a lot of times, settlement allows people access to that money sooner. Uh, and maybe they would do better at trial. Maybe they wouldn't. There's always the uncertainty of a trial, but a settlement helps you get resolution sooner. So you get paid on your case quicker. You avoid the emotional toll of litigation. You minimize your legal expenses, and you minimize that uncertainty of what is going to happen at trial. You know, so if a case is going to trial, both sides have done some research about what other people with similar injuries have gotten. That doesn't mean that's what you would get at trial, but we have an idea of what juries have done in the past, which is the best that we can do. So both sides know about the range of settlement. It's a matter of whether or not they can agree within that range as to whether or not your case settles. So this was a great topic. I've really enjoyed talking about it. Uh, if you like this, make sure to subscribe to our podcast. Make sure to follow us on YouTube. And if you have a personal injury case that you have a question, contact us. We are always here with a free consultation.